Friends, welcome to the third edition of Your Lawyer. Myself, Advocate Nainan John, a corporate lawyer practicing at the High Court of Kerala. Today, we'll be speaking about employment-related confidentiality obligations. Most of us in our career could have executed detailed confidentiality terms either as part of the employment contract or as a separate non-disclosure agreement. But interestingly, many of us may not have understood or may not have bothered to understand what those clauses are. As a result of which, we also fail to comprehend the implications of breaching those terms. 80% of the employees who have breached the confidentiality obligations have done it unknowingly. We'll be focusing on those accidental breaches rather than the 20% who have done it intentionally. So what really goes wrong? What are the typical breaches that employees do during their employment? The most common mistake happens when the employee prepares a resume. Every job seeker would like to boast about what he or she has done in the previous or the current employment to the prospective employer. That's fine. But the problem starts when the employee forgets the thin line between what can be shared and what cannot be shared. You can obviously talk about your employers, your designation, your the time that you have spent there, and probably camouflage some of your activities in a different way, but definitely cannot be sharing the intricate details of the project or the activity that you've done with your employer. Some over-enthusiastic employees even go online and share details about the company on online discussion forums or social media platforms like LinkedIn or their own personal blogs, or even when they have presentations done for third parties. The problem gets severe when the material itself is shared. For example, a designer working in a product design company shares the design that he has done, or a software engineer shares the software code, source code that he has written, or an architect shares the designs and drawings. Think about an employee working in a bank or an insurance company or a credit card company or any financial institutions like that, shares the banking financial information about their own clients. Or an employee in a hospital shares the sensitive personal information about a patient. A finance executive working in a finance department of a company. See, here all we are talking about the breaches of a contract between an employer and employee. But some of the cases, this becomes violation of a statute or a regulation. For example, the RBI regulations or the SEBI insider trading regulations or the IT Act with respect to sensitive personal information. And we are not discussing about the restrictions or the obligations of the government employees who are bound by different statutes like the Official Secrets Act or the Public Servants Act or the state-wise Code of Conduct or the Central Civil Service rules. We are focusing on the private sector employees who are generally bound by the confidentiality contractual obligations. Before we get into what the companies may do when there is a breach, we should try to understand why the companies react when there is a breach by an employee. There are three major reasons. The first reason is that when an employee discloses proprietary information of a company, the company is duty bound to its stakeholders to take immediate action to prevent further breach and to ensure that the existing employees do not resort to such, unscrupulous or accidental breaches. This is important because proprietary information forms the basis of all intellectual property rights and which is of enormous value for the company. The second reason is that when an employee discloses information about a company's client, most of the client contracts with a company will be burdened with heavy duty confidentiality clauses, and the employer will be bound by the acts and omissions of an employee. And most of these cases, this is an indemnity obligation on the company with unlimited liability. So even if it is a high performing employee or a senior executive who have done it without an intention of breaching the confidentiality obligation, the company may not be able to condone, forget and forgive those breaches because they are bound by the client confidentiality. Now the third reason is even more interesting. A reckless act of an employee can make a company in India violate a rule or a provision of a statute in a foreign country. For example, an employee working in the back-end office of a European company in India, a European company which is handling, directly interfacing with customers there, and an employee there discloses information about a European citizen, personal identifiable information in India, then his employer, that's a company, will be violating the privacy laws of European Union called GDPR. So the companies, what do they do when there is a breach? The companies take strict action. One could be a civil action, which is a civil suit claiming for damages. The second action is even more dangerous. Most of these breaches qualify themselves as offences under the Indian Penal Code or the Information Technology Act or the Copyright Act or the Designs Act, the Patents Act. And when I say offences, they call for imprisonment, fine, or both. So as employees, what should we do to avoid such kind of unpleasant situations? First and foremost, when you execute a confidentiality agreement, try to understand what it is written over there and comply with those terms. When you are in doubt, please don't take chances. Always remember, most of the employment confidentiality obligations survive your employment, which means that even if you are out of the company, you're bound by those confidentiality obligations. And from the employer's side, a non-disclosure agreement does not prevent a breach from happening. It only gives you an opportunity to initiate an action when there is a breach. So when an employee executes a confidentiality agreement, and when the employee is working with the company, when the employee leaves the company, remind him, make him understand about the confidentiality obligations. Friends, when both the employee and the employer takes a bit of caution, we can avoid a lot of unpleasant situations. Wishing all of you a happy employed life. Thank you.